Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to discuss employment authorization with respect to the K-1 visa. Now, to be clear, the K-1 visa is a fiancé visa. The K-1 is an interesting visa insofar as it is a dual intent visa, and it has this sort of one foot on each side of the system in the sense that it's technically a non-immigrant visa, but it has an immigrant intent component, as the individual going to the U.S. on a fiancé visa is specifically going there to marry a U.S. citizen and then adjust status to lawful permanent residence, aka green card status. So in a sense it's an immigrant visa, but in another sense it's only issued for a temporary stay. So basically the K-1 holder, once a visa is issued, they have 6 months to use it, and then once they enter the United States, they have 90 days in which they need to marry their United States citizen fiancé and go ahead and apply for adjustment of status. The other interesting thing about the K-1, notwithstanding sort of these timing issues, is the issue of employment authorization. It is not an employment authorized travel document specifically, notwithstanding the fact that it has this immigrant intent. And by immigrating to the United States and gaining lawful permanent residence, employment authorization is implicit with that. It's inextricably linked to one's lawful permanent residence in the United States. The K-1 visa holder, it can take a significant period of time, weeks and months, to get an adjustment of status fully processed. And there are those certain circumstances where, say, a Thai individual going to the United States, a fiancé of an American citizen, who marries and they're adjusting status, that individual wants to get a job, wants to go to work. And strictly speaking, the status in which that individual is in is K-1 duration of status, because they're waiting for the adjustment to process, and they're not work authorized. So it is possible to go ahead and apply for employment authorization in the K-1 status while one is waiting for adjustment to process. And by doing that, it's effectively something akin to a temporary green card, to allow an individual to go to work in the USA while they're processing out the rest of the case. Something to think about, though, with respect to employment authorization is, depending on timing issues, oftentimes, immigration in the U.S. has a significant backlog. Sometimes it's just simply not of a particular positive benefit, or not of a substantial benefit, because the employment authorization may come back only weeks ahead of the underlying green card being approved. So in some cases it may not be that great of a benefit. However, there are certain cases where it's rather a time-sensitive issue to get employment authorization as quickly as possible, and in those circumstances applying for employment authorization with respect to the K-1 may be a substantially positive endeavor.